Kathy. And Kathy, you want to get us started here?
Yeah, hi everybody. I hope everybody's doing good and enjoying the cooled off weather. I know that I am. So I was supposed to do John and Laura and I um are all part of the Housing Coalition, which was started by the realtors and the apartment association participates. And it was in response to various wild ideas that were being proposed at one point by the Board of Aldermen in the city of St. Louis. And we were not formed to oppose them, but more to inform them about what the consequences of various things that they were thinking of doing would be. And we had several successful meetings over the last couple of years. We had a lobbyist Maureen, who we fortunately no longer have, but she was really good. People from the city government came and spoke to us and sometimes listened to us. Um, I think we headed off something at the pass last year when they said they were going to just plunk people out from homelessness without any services and stick them in apartments. And I pointed out that they would just be getting evicted right away, right? you know, almost immediately if they didn't have some transitional assistance. And I think they've kind of backed off that idea a little bit, or maybe put more thought into giving those folks services to help them get acclimated to not living at the bus stop, to having neighbors and that kind of thing. Because if I know one thing my landlords are going to do, it's the tenant that's driving everybody in the building crazy. You're going to be calling us, and we're going to be filing a suit saying interference with the quiet enjoyment of other tenants. Because of course those folks have rights too, and the right to a peaceful enjoyment of their premises and everything. And if you have someone in there who is not ready to be in a multifamily living situation, it can be very problematic. So, tough problem, tough problem with the unhoused, but um, the straight to housing thing, I think, was not going to work by itself. They needed other help. The other thing that was going on is, we've been kind of looking to Kansas City to see what shenanigans they get up to there, because they're a couple of steps ahead of us on the crazy. And they had passed an ordinance that said you could not deny someone um, your apartment because they were getting Section 8. And the city followed along and did that. Now, our solution there was not with our Housing Solutions Coalition, it was with the Missouri legislature, which passed a bill this year, and the governor signed it, that said that local municipalities cannot do that. So you are now again able to decline to take Section 8 as a rental source in the city of St. Louis, and in fact everywhere. And I will say that Section 8 is, you know, some landlords love it. We have landlords who do work very well with it, and they get guaranteed rent, and there's social workers that will help their tenant, and it works for them. There are other landlords who it doesn't work for them. The additional paperwork, the bureaucracy, extra inspections is just not where they want to be with respect to doing it. Um, but I'm glad that the choice is back in your hands again. I think that's important. Um, we actually get along pretty well with the housing authority in the city right now. We're friends with the in-house lawyer, and that's going pretty well for us at this point. But that could change again, so you never know. And we could go back to the adversarial relationship. But they have certainly been known in the past to do some silly things. Right now, like I said, everything seems to be going along nicely, but there have been times in the past when having a tenant with that kind of government assistance could be a huge pain in the butt for the landlord. Um, what else have I got? There's a new case that came down from the Court of Appeals, and I want to tell you that this is very unusual for us in the landlord cases. The landlord cases are so small, and the cost of an appeal is, really 10 grand and up. There's a lot of picky stuff you have to do, order the record, write a brief, oral argument. It's a lot of work. So it's very difficult for us to do this in any kind of cost-effective way in a residential tenancy situation. Well, fortunately, or unfortunately, as the case may be, this case, even though it was a residential eviction, got appealed to the Court of Appeals. The tenant, I think, must have gotten a pro bono lawyer. I did not recognize the name of the lawyer, but they must have gotten someone volunteering to do this to make it cost effective. And it's all about service in unlawful detainers. This tenant, we always thought the law was that if the tenant came into court, you can only, sometimes you only have posting service, and then you can only get a possession judgment, right? We've all talked about that. Well, this tenant only had posting service, but she came into court and filed pleadings and that kind of thing. I always thought the law was that once they came to court, it was like they had been served personally. They had availed themselves of the court. They knew about the court date. They were subject to it. And I think that's what the attorneys for the landlord in this case thought. Well, it turned out that the first thing the tenant had filed was an objection to the service. And the Court of Appeals decided that that was valid. And even though she participated in other parts of the case, that her objection to service was still good. And that the service on very technical unlawful detainer grounds had been bad. When we get a summons issued, an unlawful detainer, we can't post at the same time. We have to show that we've tried to personally serve and we have been unable to. Now, sometimes, we will ask our special process server, hey, if you can't find them right away, give me back a non-est return that you can't serve them so that I can get my publication service fast and I don't have to wait, an extra month. And sometimes that works. In this case, apparently they didn't do it. They didn't have a return of not being able to personally serve. And apparently they didn't get the judge to sign off on the subsequent order of publication request for service. And you should know in an unlawful detainer, it's called order of publication, but it's pretty much the same as posting in a rent and possession. So they had some small technical defaults with the service. And a third thing that happened was when we get a summons, there's a day by which we can send it out. We can't send it out before that day to our special or to the sheriff. The sheriffs, I think, kind of know what that day is, but some specials don't know or they missed it. Well, this paper was set that it could have been sent out March 5th, but the special mailed it on March 4th, and that was held to be a default in service. These are very technical grounds. I'm not happy about this. It's a reminder to all the lawyers in my firm and to everybody to pay attention to those technical details. We probably wouldn't have done something like that. We're very aware of having to try to personally serve first and then post, and we don't send our summonses out early. But it's a caution to me that the Court of Appeals is looking that pickily at this kind of stuff. I don't know what the disadvantage was to the tenant since they showed up for court and had a chance to provide their case and everything. There's another case going on right now that's not at the Court of Appeals, but anything could happen. And this is a case where another attorney evicted the person out of the wrong apartment. Bad. That's bad to do. So they evicted the wrong person. What happens in an eviction in the city and the county? The sheriff comes and kicks you out and changes the locks. We don't know what happened to their belongings. This is a story that we were told in court earlier this week, because court is really like gossip central for the lawyers. We're just all hanging out telling each other stories. But yeah, so we occasionally get a referral from a client where the client has written down the wrong address, or the address on the form they send us is different than the address on the lease. So if you're wondering why we're very picky about getting the form and getting the lease and having all that stuff, it's because we want to check everything so that we don't evict someone out of the wrong apartment and get everybody sued. So it's important to be very careful with these picky things. It's interesting to me that the Court of Appeals was this picky, though, and it's definitely kind of a new direction in the law. And I think in the 40 years that I've been doing this, we have moved more from anything goes for the landlord to, oh, wait, the tenant has rights too. And there's more pickiness and more chances to get continuances and all that kind of stuff. So John was so kind as to mention the thing I'm doing on Tuesday at the apartment association, which is in the in there with the realtors on Olive. I think he's going to try to send out an email about it, or you can go to the apartment association website and look. If you're a member of the apartment association, it's $25. If you're not, it's 50, pretty cheap. It's going to be 3 hours, and I'm going to cover all the topics and answer people's questions, and maybe even have a couple of guests come by to say hello to people. So if you'd like more in-depth talking about the stuff I already talk about, come on over. If not, I'll keep seeing you here about once a